let's take a look at background checks from an employment law perspective. Background checks are used to verify information provided by candidates and determine whether any disqualifying factors exist. These checks might entail contacting references, verifying past employment, confirming necessary degrees, licenses, and other credentials, and checking driving or criminal records. A basic legal motive for conducting background checks is the potential liability of employers for the harmful acts of the people they hire. The common law doctrine of respondent superior, let the master answer, makes employers directly liable for the harm to others caused by employees acting within the scope of their employment. Employees are deemed to be acting within the scope of employment when their actions relate to the kind of work that they were hired to perform and take place substantially within the workplace during work hours. By way of example, an employee of an automobile dealer was acting within the scope of employment when, on a public road, he stopped the driver of a truck that the dealership was seeking to repossess and fired shots into the tires of the vehicle. Even though the employee's acts were criminal in nature, the court deemed them within the scope of employment and the dealership was liable under respondent superior. In reaching this conclusion, the court emphasized that the employee's sole motive for the confrontation was to repossess the truck on behalf of the dealership. In contrast, two drivers of an armored car were not acting within the scope of their employment when they became enraged at a motorist, repeatedly attempted to run his car off the road, and threatened to blow off the motorist's head. The court reached this conclusion even though the drivers were on duty in the employer's truck and had brandished weapons provided by the employer. The legal concept of negligence is based on the idea that people sometimes have a duty to others to exercise reasonable care in carrying out certain activities. When that duty is not met and this failure is proximate, relatively direct, cause of harm to others, the party that failed to live up to its responsibilities may be found to be negligent. It's not necessary to show that the negligent party intended for anyone to be harmed. Employers can be found negligent with respect to a wide range of human resource activities, including hiring, supervision, and training. The significance of negligent hiring is that it extends an employer's liability for harm caused by their employees beyond actions undertaken within the scope of employment to harmful actions that lie outside the scope of employment. If an employer fails to meet its duty to conduct an adequate background check and hires an unfit employee who uses his or her position to inflict harm on others, that employer may be liable for negligent hiring. Negligent hiring cases often hinge on the first element, whether the employer had a duty to do more to screen out an unfit employee. This single standard is applicable in all cases for how careful a background check must be done, if at all. Instead, the degree of care that an employer must exercise in hiring depends on three factors: public policy, foreseeability, and knowledge. Some industries and occupations have specific legal requirements for screening employees. Even when the law does not specify a particular screening procedure, courts sometimes look to public policy as an indication that a particular type of employment is sensitive and calls for greater care in hiring. For most jobs, public policy concerns do not enter the picture. Instead, the degree of care that an employer must exercise in hiring depends heavily on foreseeability. The question is whether a reasonable person of average intelligence would be able to foresee that the hiring of an unfit person for a particular position would render injury or harm to others likely. Foreseeability stems primarily from the nature of the position into which an employee is being hired. The more sensitive the position and the greater the foreseeability of harm, the more extensive the background check should be. Jobs that create greater foreseeability include contact with children, the elderly, and other vulnerable groups, jobs involving personal care and medical treatment, and responsibility for security and/or the use of firearms. Foreseeability of harm is a slippery concept, and courts are not entirely consistent in how they apply it. Courts sometimes consider whether a special relationship exists between the employer and the person harmed. A special relationship exists when the harm that occurred was a direct consequence of employment and the employer would have received some benefit, if only direct, from the meeting at hand in a harmful act that occurred. Knowledge refers, in this context, to the fact that the employer was aware, or should have been, that the person hired was unfit. Knowledge pertains to those characteristics of the person being hired that render him or her unfit. If an employer hires an employee without conducting an adequate background check and they proceed to harm others, the employer is still not liable for negligent hiring if information showing unfitness was not available upon hire. The evidence of unfitness must bear a relationship to the nature of the position and the type of harm that occurred to constitute knowledge. The evidence of unfitness must also be relatively specific. Although most negligent hiring cases consider whether the employer was obligated to do a more thorough background check, plaintiffs must also show that their employers failed to live up to their duties which directly caused harm. Foreseeability and proximity are closely related. Foreseeability pertains to whether harm could be anticipated before the fact, and proximity involves the connection between events as they actually unfolded. Depending on the circumstances, an adequate background check might include contacting references, verifying past employment, and checking driving and criminal records. Negligent hiring claims are premised on employers not doing enough to screen out unfit employees. But is it possible for employers to do too much and delve so deeply into the backgrounds of applicants as to invade their privacy? In a case involving NASA contract employees, the Supreme Court left open the possibility that employees enjoy a constitutional right to informational privacy when being subjected to background checks by government agencies. The contract employees, scientists, engineers, and administrative personnel were, in the aftermath of the 9/11 terrorist attacks, subjected to extensive background checks required of federal employees. They specifically objected to detailed questions about prior drug treatment and broad, open-ended inquiries into their fitness for service directed to former employers, landlords, neighbors, and other sources. The court assumed that a constitutional right to privacy exists in the context of background checks, but found that the challenged inquiries were reasonable and served legitimate government security and employment interests. Furthermore, the government was not required to show the necessity of its inquiries or that the questions were no more intrusive than necessary. Thus, any constitutional limits on invasive background checks, which would apply only when the government and not a private employer is doing the questioning, are not likely to be very stringent. Ironically, the validation of their privacy concerns that NASA contract employees failed to obtain from the Supreme Court may have come from subsequent events. An interesting postscript to their legal case occurred in 2012 when a NASA laptop was stolen from a parked car. The laptop contained unencrypted personnel information like birth dates and social security numbers and other information from background checks of perhaps as many as 40,000 current and former agency and contract employees. Gathering sensitive information on employees and job candidates necessarily raises questions about whether there will be secure storage and handling of that information. One of the clearest indications that a prospective employee might be unfit for a position is a history of criminal activity. Failing to check for criminal records is probably the surest route to negligent hiring. However, legal issues affect both access to information about criminal histories and the use of that information. Conviction information is not always available and should not be used to exclude all persons with criminal histories from hire. It's important to realize that the number of people in the United States who would have been convicted of crimes is large. The United States imprisons far more people than any other country in the world. With 5% of the world's population, the United States has nearly 25% of the world's prisoners. Approximately 700,000 persons are released from jail each year. It's estimated that a quarter of all adults have had some type of criminal history. At the same time, more than 90% of employers conduct criminal background checks for at least some of their positions. Policies limiting employment based on criminal histories stand to affect significant numbers of people. It's important to distinguish between arrests and convictions. Individuals are arrested and are often released without actually being charged. They might be picked up for questioning, mistaken for someone else, or a number of other reasons. The U.S. system of law operates on the presumption that persons accused of crimes are innocent until proven guilty. Thus, an arrest cannot be presumed to say anything valid about a person's character or fitness for employment. By comparison, a conviction for a crime following either a trial or a guilty plea is stronger evidence of lack of fitness, but crimes differ greatly in their severity. Felonies are more serious crimes for which imprisonment of more than a year in state or federal prison may be imposed. Misdemeanors are less serious criminal offenses that may be punished by a fine or imprisonment of up to 1 year, usually in a county facility. Conviction records, unless sealed or expunged, are public records and theoretically accessible. However, states sometimes have laws that limit access to this information and allow people to apply for jobs without revealing their criminal history. Law enforcement agencies do not routinely make their comprehensive national databases available to employers. Moreover, retrieving information about convictions is not as simple as just logging onto the internet. Criminal records have been shown to be incomplete and inaccurate in many cases. Many employers avoid dealing directly with these problems by contracting background screening companies or private investigators. Regardless of who assumes the responsibility of checking for criminal convictions, the comprehensiveness of the search is an important factor. A search limited to a single state or a brief period might not yield the relevant information. If criminal history indicates unfitness for positions where there's foreseeability of harm to others, both the threat of negligent hiring suits and the basic ethics clearly dictate that unfit candidates should not be hired. However, problems arise when employers overreact to this legitimate concern by seeking to exclude anyone with prior criminal conviction, or worse, anyone who's been arrested. Overly exclusionary criminal history policies have been successfully challenged based on their disparate impact. Most often, when people think about credit reports, they have in mind information that is gathered about their credit worthiness and used by financial institutions in deciding whether to make loans or offer credit cards. However, credit reports are very broad and are also used by employers in making hiring decisions. The Fair Credit Reporting Act, known as FERCRA, is a major federal law regulating the gathering, sharing, and use of information by employers and consumer reporting agencies. It distinguishes two types of credit reports: consumer reports and investigative reports. The FERCRA defines a consumer credit report as any written, oral, or other communication of any information by a consumer reporting agency. The report covers a consumer's creditworthiness, credit standing, character, general reputation, and is expected to be collected for the purposes of serving as a factor in establishing the consumer's eligibility for employment purposes. When employers have other firms check into the employment histories, criminal records, licenses, and other information about candidates or employees, they're obtaining a consumer credit report that falls within the requirements of FERCRA. An investigative report contains information about character and reputation drawn from personal interviews with friends, neighbors, or other associates. Reference checks performed by third parties qualify as investigative reports. Although these reports may contain financial information such as bankruptcy filing and repayment of loans, they can go far beyond financial matters to reach all other aspects of background checks. For the investigation to fall under the purview of FERCRA, the information must be obtained from a consumer reporting agency. This also encompasses companies that perform background checks for employers. The FERCRA is responsible for the problem of inaccurate information being gathered and sold about people, resulting in their being denied jobs, mortgages, and other opportunities. It has many detailed provisions. One important requirement is that prospective employers must disclose to a job applicant that a credit report will be obtained and must receive the applicant's authorization to do so on a consent and disclosure form. If, based in any part of the information from a consumer credit report, an employer intends to take adverse action, such as not hiring or promoting, the employer must first provide the individual with a pre-adverse action disclosure. The purpose of this requirement is to provide individuals with notice that negative information about them exists and afford them the opportunity to address possible inaccuracies. However, employers are under no obligation to reconsider a candidate even if erroneous information is subsequently corrected by the consumer reporting agency. Furthermore, the FORSEEABILITY does not cite any specific period of time that must elapse before an adverse action can be finalized. After taking an adverse action based on a consumer credit report, an adverse action notice must be provided. If the accuracy of a credit report is challenged, a former employer providing the challenged information has an obligation to reinvestigate to confirm the accuracy or the correct information. Reporting agencies are prohibited from including information relating to civil suits, civil judgments, arrests, paid tax liens, accounts placed in collections, and other adverse items of information when it dates back more than 7 years. The FORSEEABILity regulates how employers must go about obtaining credit information when third-party sources are involved, but it does not limit the use of such information. At least 10 states have enacted laws prohibiting or limiting the use of such information by employers, although these laws typically make exceptions for jobs in which personal finances might be especially relevant. As with criminal history, the EEOC has taken a keen interest in the potential discriminatory effects of employer reliance on credit information and sued several employers who engage in this practice. The underlying legal theory is that the use of credit history is likely to have a disparate impact on persons of color, and there appears to be little evidence that linking credit history to job performance actually matters. Employers should carefully consider whether to use information about individuals' personal finances in making employment decisions and refrain from doing so if there's not a strong business rationale or job-related reason. We can be more certain that plaintiffs who are not hired because of previous bankruptcy filings will not be able to invoke the protection of federal bankruptcy law. Courts have interpreted bankruptcy code as prohibiting only the termination of such employees, but not as a refusal to hire them. Failure to check references, particularly recent ones that possess information regarding wrongdoing by an employee at a previous job, can be evidence of negligent hiring. But it is former employers being asked for information about their former employees that have the most to worry about regarding references. The principal legal concern is that former employers will be sued for defaming their former employees. Other worries are that former employers may retaliate against their former employees or negatively provide misleadingly positive referrals. Defamation claims can arise anytime a person makes a statement about another person, but here the focus is on references provided by a former employer. The term reference applies here to any information that a former employer provides to a prospective new employer. The former employer need not be specifically designated by the former employee as a reference. The gist of a defamation claim is that a false statement that reflects badly on a person is communicated to others. Defamatory statements are not merely harsh or negative, they must be substantively false. As such, it benefits employers responding to requests for references to ensure that the information provided is as accurate and objective as possible. Among other things, this means basing responses to requests for information on inspection of documents rather than memory, confirming statements to known facts rather than speculation or impression. It's also helpful to have requests dealt with by designated persons who are accustomed to writing letters of reference and familiar with assessing and accessing information regarding former employees. Although truthfulness is an absolute defense to a defamation claim, Employers do not want to be in the position of defending the accuracy of all of their statements. Another defense available to employers is consent. If a former employee consents to her former employer providing a reference, statements that might otherwise be defamatory will not be subject to former employer liability. It makes sense for the employer to require that any request for a reference be accompanied by a written release of information form that's signed by the former employee that grants permission to communicate information about them. This precludes off-the-cuff responses to telephone inquiries about former employees, which is also desirable from the standpoint of accuracy, but does not impose an unreasonable burden on other employers seeking references. Although requiring release forms is definitely a good idea, there's a legitimate question as to whether this constitutes informed consent on the part of former employees, because they do not know what their former employer will say. A means of gaining more fully informed consent is for employers to negotiate with employees prior to them leaving employment and to mutually agree on letters of reference. However, when the employee's departure is acrimonious, it might not be possible to agree on the contents of the letter. Some employers might also be concerned that their statements could be used against them in wrongful termination cases. A third defense against defamation claims is what the statements are made, even if otherwise defamatory, were privileged. The law recognizes that communication between employers about prospective employees serves important purposes. It also recognizes that if employers have to worry about strict accuracy of everything they say about former employees, this will choke off the flow of necessary information. So, former employers providing references are shielded from defamation by claims of qualified privilege. This privilege or immunity from liability is conditional rather than absolute. In general, qualified privilege can be lost if false statements are made with malice, reckless regard for the truth. Qualified privilege shields communications only with others who have a legitimate need for that information. It's critical to have a substantive, preferably documentary, basis for references. Malicious intent is less likely to be inferred if employers refrain from drawing conclusions about whether former employees should be hired. A statement that someone should not be hired can sound, especially in court, as though a grudge is the motivating speaker. What if references are provided, but they are misleading and fail to include evidence of unfitness known to the former employer? Concern over possible defamation claims or simply the desire to get rid of problem employees might prompt some employers to provide overly positive references that misrepresent former employees to prospective new employers. Can an employer be sued for negligence in referring an unfit employee who harms others in his new job? In a number of states, the answer is yes. In one instructive case, disciplinary action was initiated against a correction officer who was accused of engaging in improper sexual conduct with female inmates, and the officer chose to resign. His former supervisors and the prison agreed to write a letter of recommendation for him. The letter was effusive in its praise for the former employee and omitted any mention of the incidents that led to his resignation. When a mental health facility called the prison, the former employee was again heartily recommended. Within a month of being hired at the mental health facility, the former officer sexually harassed and assaulted a female patient. The court decided that although voluntary, once they decided to communicate information about the former employee, they had a duty to not misrepresent him by withholding material negative information. Employers that choose to respond to requests for information about former employees should not do so in a selective or misleading manner that conceals known evidence of unfitness. At least one more significant legal concern exists regarding references. That's retaliation. In one such case, an employee was fired and filed a charge of race discrimination against his former employer. While his case was being investigated by the EEOC, the employee applied for a job with another company. The company asked his former employer for a reference. The former employer provided a damaging reference, which the employee alleged was done in retaliation for his discrimination charge. The U.S. Supreme Court decided that the former employee could sue his former employer for retaliation. Care should be taken to ensure that references provided are no more negative than the facts warrant. Many people come to the United States from other countries to work. Employers are responsible for verifying that all persons hired have the legal right to work here. The Immigration Reform and Control Act of 1986 and more recent developments have moved the workplace to the front line in the government's efforts to curtail illegal immigration. Immigration has long shaped the U.S. workforce. The Immigration Reform and Control Act has two main requirements. First, all employers are prohibited from knowingly hiring or retaining on the job unauthorized aliens. Second, employers with 4 or more employees are prohibited from discriminating on the basis of national origin and citizenship. This protection against discrimination applies only to citizens and legal immigrants. Non-discrimination provisions were included in this law because Congress did not want employers to respond to the Immigration Reform and Control Act by excluding all foreigners. It does not conflict with the requirement that employers screen out undocumented workers, nor does it prohibit employers from preferring U.S. citizens for employment when 2 individuals are equally qualified. To avoid hiring or retaining persons ineligible to work in the United States, employers need to do a number of things. The following procedures apply only to people hired and not to all applicants. Within 3 days after a newly hired employee begins work, the employer must verify his eligibility to work in the United States. This is done for all newly hired workers and is not simply those whose employment eligibility is questioned. This verification is accomplished by viewing documents establishing eligibility to work by recording the types of documents viewed on the Employment Eligibility Verification I-9 form provided by the federal government. Documents can establish identity, eligibility to work, or both, and typically include a social security card, a driver's license, a birth certificate, a U.S. passport, or a permanent resident card. A full list of acceptable documents can be found in the back of the I-9 form. Other than certified copies of birth certificates, only original documents should be accepted. Though not required to investigate the authenticity of documents, these documents must reasonably appear on their face to be genuine. Retaining copies of documents can help prove that the decision to accept them was reasonable. I-9 forms and any copies of documents must be kept separate from employees' personnel files and retained for 3 years from the date of hire or 1 year after employment is terminated, whichever is longer. Thus, the minimum period of time that these forms must be kept is 3 years. Employment for more than 2 years extends this period. For much of its history, enforcement of the Immigration Reform and Control Act has been lax. Fake documents were readily available and government enforcement actions were infrequent and carried minimal sanctions for employers. Enforcement of the act became more serious around 2006. Initially, this entailed highly publicized raids on workplaces in which undocumented workers were rounded up for mass deportation. Another facet of the recent immigration enforcement environment has been an effort to encourage and require employers to use government databases to verify employment eligibility. E-Verify is a program under which employers can electronically access government databases to verify the eligibility of employees to work in the United States. The use of E-Verify is still voluntary and for most employers, but an executive order issued in 2008 made participation in the program mandatory for federal government contractors.